Okay, hello everyone. I hope you're doing well. This is the video lecture for Chapter 4, Legal Liability of CPAs, Public Auditors. And ultimately, this is the last chapter in our little first subset here. And remember how I described this before. This kind of provides, these 4 chapters kind of provide the environment in which the CPA or the public accountant is operating. And so really the legal liability of CPAs gets to the incentive structure of audit firms in the sense of what are they trying to avoid, right? What is the big cost they're trying to avoid? Well, they're trying to avoid lawsuits, right? And so that's going to be helpful, and you'll kind of see as we move through the class how this can impact how auditors plan their audits, because ultimately they want to get the fees in and they want to manage the engagement towards profitable, but they also have to manage the risk that they have that they're exposed to by being an auditor of a company, and that includes publicly traded and privately traded companies. So just like all the other chapters, there's a set of learning objectives, and I've labeled those with the high, medium, and low priorities. This is a fairly important chapter. Like I said, it kind of provides a lot of the incentives for how and why auditors plan the audit and execute the audit the way they do. And so there's a lot of significant learning objectives here. So let's work our way through these. So our first objective is pretty important. Describe the types of CPA liability that are out there. Right? And so how big of a liability can CPAs have? Well, potentially it's a lot bigger than other professions because of a couple of reasons. One is the number of parties that could suffer significant losses. So think about how many shareholders there might be of a company. That's can be a pretty substantial number of parties. Compare that to like a dentist, right? They mess up one service, that's just the one person that they messed up, right? There's not a whole lot of other individuals that are impacted. Same thing with doctors. Same thing with lawyers, right? They have a limited liability relative to CPAs, but just because the number of parties are involved. And so those can be some pretty substantial amounts. And they can go above any insurance that might be available for the firms to cover their professional liability. Some insurance companies have dropped auditors and dropped providing insurance to audit firms because of the excessive liability that's out there. Some estimates are that up to 20% of firms' revenue is often set aside or used for defense cost relative to lawsuits. So this is a really substantial cost that auditors are trying to avoid and manage. So obviously some cases are due to poor audit performance, right? I think that's often the case. A lot of times though there are what you might call hindsight bias that comes in to this process, to where, remember how I said that there's a lot of uncertainty in financial statements, and some of that uncertainty is due to predictions or estimates that the managers are making, and then auditors are trying to provide assurance around, but there's a range, and so sometimes those estimates don't prove to be true, and so a lot of times the stakeholders argue that the estimates are unreasonable, but it's only because they have hindsight bias, right? They can look and see that the estimate didn't pan out, but it'd be pretty hard at times for a reasonable person to actually see that is likely what's going to happen when you have to actually make the estimate. Other things, there's a theory in audit research called the deep pockets theory, and it's just the idea that sometimes some of these firms that have problems, right, don't have a lot of extra cash sitting around to be able to pay lawsuits, whereas CPA firms sometimes do, right? Sometimes they have a substantial amount, for the very successful ones as a possible pool, and so the trial lawyers recognize that and often try to go after the CPA firms just because they have a much higher ability to pay than at least some of the clients of the auditors in terms of the managers and things like that in order to pay back losses. So that kind of sets the stage with the kind of liabilities that are out there, why we even have those a liability. The next learning objective is trying to think about this difference between common law and statutory law. So common law, if you remember from any of your law classes, is essentially judge-made law, right? It's law that is the result of cases that have been brought to trial, that have been adjudicated, there's been opinions written, and those opinions then form the basis for future opinions, right? And so all those build up together, at least that's the idea, into forming a cohesive law in a given area, right? Having all these cases being tried, and then, having some kind of consensus that develops over time. Statutory law is obviously statutes, right? And I'm kind of giving away this next slide here, but common law can be codified, right? So there's a uniform commercial code that basically takes some of the existing common law through these case decisions and then makes it into a law, but it was initially common law, right? And so some arguments are that law is more efficient than the statutory law, which usually is a point in time. It takes longer to make adjustments to it. It's not as flexible, and so it can be out of date. Even though maybe at the time it was written, it might be up to date based on the possibilities, it quickly goes out of date if there's new situations that arise. And so this is where there's kind of some differences between these two. So they're created differently, common law and statutory law, and as a result, the liability for CPAs is a little different under these two. So let's first look at why we can even get to liability in the first place. And so the first one is breaching of contract, right? So let's say a firm hires an auditor to do an audit within a certain period of time, and they take too long, right? That's a possible breach of contract. And so the firm could possibly sue them. Let's say they missed the SEC deadline for filing because the auditors drug their feet. Another possible source would be negligence. This is under tort law. Tort's just a fancy word for harm, right? And so there's two levels of negligence. Ordinary negligence, which is just not exercising an expected degree of care as a CPA. And then gross negligence is a complete disregard for basically your duty as a CPA, right? And so these two levels of negligence have different standards and different defenses to them, and we'll see that as we kind of go along. Fraud is another area, right? And so this is where case law or common law has developed a pretty robust way or approach to determine fraud. So there has to be a misrepresentation. The misrepresentation has to be material. The person has to know that it is untrue, or they have to have such a disregard for the truth. And there has to be intent to deceive another party. And this is usually where fraud gets hung up, is trying to prove this intent to deceive, right? Because that sometimes is harder to find evidence of. Sometimes you can find, a smoking gun through an email or something like that, but oftentimes it's difficult to prove intent. And there has to be an injury to the other party. So you have to have these 5 things in order for there to be fraud. So that's kind of initially fraud. That's kind of the full case of fraud. Constructive fraud basically takes away intent to deceive in the case of gross negligence. So you don't have to have an intent to deceive, but if you have such an indifference, or you do such a poor job in terms of exercising your due care to rise to the level of gross negligence, then that becomes constructive fraud. Okay. Another source of liability is statutory liability from the SEC Acts, and we'll go through those as we get closer. These other 3 are largely more around common law, so breach of contract, negligence, and fraud. And then we'll talk about the statutory later. There are also certain criminal statutes that are available, if you violate federal securities acts. Now, class action lawsuits aren't criminal, so that bullet point is a little bit off. But oftentimes, the class action lawsuits are trying to allege that that parties violate the Federal Securities Act. And then lastly is the RICO Act. It was basically set up for organized crime, but it can be used against the CPAs. If you remember famously, like Al Capone, right? He was never convicted for his organized crime as a mob boss, but they did get him on tax evasion, right? And so this is where the RICO Act comes in, because if you're engaged in illegal activities in your business, you're not going to report that as a line item on your financial statements, right? So you're gonna cover that up. So that's where the RICO Act comes in. So that's the sources of CPA liability. If we look at these proof requirements, then what does it take in order to be successful as a party trying to sue a CPA firm under these? First under the common law, and then what kind of defenses are available. And so if we look at what needs to be what we need for proof under common law, you need to show that there's a duty, right, that is being violated. So CPAs, whenever they have an engagement, they're accepting, basically they have a duty to exercise due professional care. That's usually pretty easy. You have to show that the CPAs actually breached that duty through their actions, either not performing an engagement or performing it so poorly that they miss significant issues. You have to show, if you're the plaintiff trying to bring the lawsuit, that you've suffered losses. So you can't be, for example, a potential shareholder and I thought about shorting the stock because I didn't think the performance was very good, but I definitely would have shorted the stock if the firm had not managed earnings, for example. So it can't be a potential injury; it has to be an actual injury, and they have to be connected, right? What the firms did, what they didn't exercise professional care over, has to be directly related to the losses, right? So if there was significant earnings management, then and let's say, for example, and then there was a restatement sometime later, right? And the restatement was around the area where there was some kind of not just intentional earnings management, but inappropriate earnings management. And so because of that restatement, the stock price dropped, right? That's a proximate cause, right? If earnings had been stated correctly, then the price wouldn't have gone down, and therefore it was a direct cause. So you have to have that. It can't be something like, the CPAs forgot to make managers put in a footnote that was really minor, and even when they corrected it, the market didn't react at all, right? There's no loss there that you can point to from that error, right? And so you have to have those connected. It can't just be any error, and it has to be an error that you can connect to a loss. All right, some other elements here is that the duty is the responsibility or the duty is defined by the auditing standards, the engagement letter, and other legal considerations. So the engagement letter is usually very important. It lays out very specifically what the auditors are going to do, what period of time, how long they're going to be working on it, what the outcome is going to be, the fee structure, all those things. And then breach of duty is basically saying they didn't perform those obligations, or their performance didn't meet the standards, right? So this is where the lawyers are going to dig into the auditing standards, try and find, and then they're going to request to see the working papers for auditors and try and find situations where the auditors didn't do what they were supposed to do, right? Now, there are occasions where there are misstatements, and it doesn't always mean the auditors are negligent just because there's a misstatement, right? You could have collusion from managers, and even the auditors did, an audit to the specifications of the auditing standards, it's possible that managers could have colluded in a way that would have been really difficult, if almost impossible, for the auditors to discover it, right? So just because you have a misstatement, it doesn't always mean there's negligence on the behalf of the auditors, even though a lot of times the public likes to assume that. We've talked about losses before. A lot of times those are shareholder losses. There are other situations, it could be a debt holder that doesn't get paid, or a debt holder where a debt covenant would have been violated and they would have been given certain rights if the misstatement wasn't made. So there's other types of losses, but a lot of times it's shareholder losses. And we talked about this causation, how it has to be approximate cause. So how do you defend against it? Ultimately, if you, like I said, as an example, you might not have done something according to the auditing standards related to a certain area. Maybe it's some kind of disclosure. But if that doesn't directly cause the loss, then that would be a good defense, right? If there are other things, so the contributory negligence is where the client is basically engaging in some kind of negligence that you may argue is a greater cause of the loss rather than the auditor. So again, if managers collude together to make sure that they keep some fraud from auditors, then that's going to be a defense that the auditors are going to rely on. And then there's two types of liability. There's proportionate and there's joint and several. And so the proportionate basically just means that the auditor would be responsible for their proportionate amount of the loss, right? So let's say a judge basically said, well, we think auditors were about 30% responsible for this problem, managers were 70% responsible for the problem. Well, then if the total losses incurred were $1 million, then the auditors would only be on the hook for $300,000, right? 30%. And so that's proportionate loss. The joint and several means you're responsible for your portion, and if one of the other parties doesn't pay, you're also responsible for their portion, right? And this is where this deep pockets theory comes in, because even if the firm is struggling, doesn't have a lot of cash on hand to pay out to the shareholders, then the shareholders could try to go after the auditors and make them pay for management's portion of the misrepresentation, okay, as an example. And so clearly, if you're the auditors, you'd rather be under this proportionate liability rather than the joint and several. And we'll talk later about when which of those might kick in, okay. All right, then we have this piece about third parties. Okay, and so clearly they have to be able to show some things, right? The losses are due to the CPA's performance. We've talked about that before. The CPA breached the duty of professional care, right? Those are the minimum things. And that it sustained the loss because it relied on something that the auditor should have corrected, right? So typical cases, gross negligence will establish liability. Whether it's under common law, any common law approach, gross negligence will establish liability. Whether or not you get to ordinary negligence to get to liability depends on basically the jurisdiction and their approaches to common law. Okay, and there's three common approaches to this determination, and so there's kind of three levels. Okay, so the first one is called the known user approach. So which users can actually sue a CPA firm? Okay, and so the first one is the ultramarines approach. I think I'm pronouncing that right, but I just think of it as the known user approach. And so this is the case where auditors knew that the audited financial statements were for use by a particular person, by a known user, like a named known user. So for example, you have a firm that's non-publicly traded, they're going to get a loan, and the bank says you have to have an auditor come in and audit your financial statements, right, in order for us to give this loan. So the whole purpose of the audit is to provide comfort to this one lender, right? That's a known user approach. And so if they take that approach, then ordinary negligence in that case is enough to show liability, The next level is this foreseen user approach or restatement approach. So here, the auditors knew that the financial statements were used for a certain purpose, but they didn't know the specific user. So they knew that management wanted to go and acquire some additional capital, or possibly to sell the firm in this example. They just didn't know who it was going to be, but they did know the purpose. And so they can foresee, the auditors couldn't foresee who the users of the financial statements would be. And so in that case, ordinary negligence is good for any of those foreseen users. And then the last approach is even wider in terms of casting a wider net of possible users and who can bring these liability claims under an ordinary negligence test, and that's the foreseeable user approach. And here, it's a much lower test in the sense of auditors just have to realize that it was reasonably foreseeable that the financial statements would be used by a particular user. Okay, so that's a pretty low test, right? So if you're creating general financial statements, that casts a pretty wide net as far as who could possibly bring a lawsuit and only have to show ordinary negligence. Okay, so the different approaches essentially are, the first one is a very narrow net. You have to know exactly who that user is in order for ordinary negligence to be used. The foreseen user approach basically says you have to know the purpose, even if you don't know the particular user. And then the least restrictive is this foreseeable user approach. You just have to realize they could have been used for this kind of user, right? In order for that other user to be able to bring a lawsuit against you. Okay, so these next slides just kind of give background on these. I'm not going to go through these details. Feel free to look at them if you'd like. But this is ultimately kind of who can recover under this ordinary negligence test, right? Which is not as hard to prove as gross negligence. Okay, so depending on what approach the state court or the federal court takes, that's going to dictate who can bring a lawsuit under only at ordinary negligence level of evidence or claim that they can bring. Okay, so I'll stop there and then pick up with this learning objective on the next video.